Good afternoon. We are now holding our first hearing of the Estates and Trust Subcommittee. My name is Delegate Elizabeth Embry, and I'm chairing the subcommittee, and our members are here. We are hearing two bills today, and we're going to start with House Bill 17. The sponsor, Delegate Cardin, is the sponsor for that, as well as House Bill 65. The plan today is to talk about House Bill 17 and the amendment that the delegate is offering, and hopefully vote on that bill. And then we will discuss House Bill 65, but not vote on that bill today. So with that, Delegate Cardin, do you want to begin by presenting House Bill 17 and your amendment?
House Bill 17, which is not a rehearing. I'm just going to try and summarize. It expands the basis upon which a determination can be made that a given county is the proper venue for administrative or judicial probate of the estate of a decedent who was not domiciled in the United States. Basically, if we need to have a place where we can establish somebody for the purposes of administering the estate. And so this bill will allow for that if the person is domiciled somewhere outside of the United States. There was an amendment that we offered that it was, I believe, a technical amendment that was requested that we had drafted. I do not have a copy of that with me.
We're going to do the screen share right now so everyone can look at it.
There was no opposition to the bill, Madam Chair, and there were really not many questions. It was really, this is really to help expedite the ability for people to get their estates managed quickly. And
are there any questions?
I just want to make sure I'm clear on the bill. So this is for anyone who has inherited some, has some inheritance, but they don't live in the United States. Could this be someone who once lived here or have never lived here? So let's say if you have someone who's retired, they moved to the Virgin Islands, not the US side of it, but they moved to the Virgin Islands, but they now have come into this inheritance. Is this to make sure that they're able to access those, the inheritance, whether they're in the States or not?
Yeah, because if we couldn't, then we can never close the estate because the person who's properly supposed to receive the assets wouldn't be able to receive them. That's my understanding. We can
screen share.
I think you have Miss Broyles on the line here who can probably answer those questions.
Miss Broyles, are you there?
Yes.
Thank you.
Oh, sorry.
I don't know if you heard the question though, Miss Broyles.
No, I didn't.
Delegate Conglo, would you mind
re-asking?
Thank you.
Yeah, I was really seeking clarification. So what this bill does is that it will allow someone who lives outside of the United States to access any assets that they've inherited. So if someone, let's say they were an American citizen, lived here once upon a time, retired, moved to Panama, that this person would still be able to access their whatever's been bequeathed to them, I guess.
Essentially, yes. So, so as I think everybody knows, our culture is globalizing, and it's a lot more common for people to live in one place and move around and die somewhere else. So it's been a problem in Maryland, and that practitioners are seeing where we have exactly that situation where somebody died, they lived in Maryland at some point, and then they went somewhere else, but the current venue rules are really only clear that an estate can be open where there's real estate in Maryland or where there is there's other property that has a legal situs here. And so financial accounts do not really have a legal situs here, and they're considered intangible, and they're technically their legal situs is where the person was domiciled, the decedent was domiciled. So this bill expands the venue rules so that the personal representative has the authority to open an estate in Maryland. And that is how eventually the heirs or the beneficiaries get the assets, is that estate needs to be opened, and the Register of Wills needs to issue letters of administration that essentially authorize the personal representative to transfer the assets to the heirs. So yes, so it's not, but it's not necessarily the beneficiaries that they don't automatically get access. It allows the legal process that has to happen,
whether they're in the States or not.
Right.
Whether
Well,
they ever lived here, like, would it apply to someone who's like a non-US citizen as well?
it could apply. So there are different ways that the venue rules are expanded here. So I mean, there's not really authority if there's no connection to Maryland. But you'll see that in I guess paragraph 4 of 5-103. There are some various ties to Maryland that would enable a personal representative to open an estate. So if there was a lawsuit that happened here, like they were traveling here and there was an accident here that happened, like think Key Bridge collapse, if there was a foreigner who died in that, that would give you venue under this law or under the bill. If the personal representative who's named to administer the estate lives here, that would give you site venue. If the heirs live here, if there are banking connections here, and then the last one is that if the Register of Wills decides that it's in the interest of justice.
Thank you. Delegate Valentine?
Thank you, Madam Chair. That ties into my question, and I'm looking at on the reprint, which is dated, I have it 2/11/26, and it is that paragraph, item 4, where I think it was Ms. Broyles brought up. Is that a hierarchy of where we decide? So for example, in my analogy, it would be, say, I'm a heir or an administrator. I'm going to be the administrator, and I live in Frederick County, and they had assets in Anne Arundel County, but there were other heirs in Washington County. Is this determined to be like a hierarchy of how we decide, or where that decision is made to open the account in that listing of that you just read?
In paragraph 4?
Yes, is that
No, it's not a hierarchy.
Okay, I was just trying to determine if we had like 3 different jurisdictions, how would we decide which one to be in? So say the financial institution is in Anne Arundel County where the account is. I'm going to be the administrator and I live in Frederick County, but there might be other heirs live in Wycomico County. How would we decide where to open that account?
That's a great question. I think there could be some options of different venues that would all be considered appropriate. And that does happen now sometimes, and it's something where sometimes an estate will need to be like moved from one county to another. I mean, I think
by the person opening the estate, or what? That's a good question. What would the process be?
I mean, I think whoever's opening an estate would need to decide where the strongest ties are. And there is, like, if there is real estate, then, so if you go up to A, we have like 1 through 4 are priorities. So if they're domiciled in a county, that's automatically the top priority. If they had real estate, that is.
I'm sorry, which section are you in? I'm trying to read along.
Oh, it's 5-103A. Like number 1 is if they're domiciled in the state, that is the place where their probate happens.
Right.
And if they were not domiciled in the state, wherever the largest value of their property is located.
Okay, I see that now.
So like where there are really strong connections to one county over another, it is dictated where what the priority would be. But if the ties are less strong, there's not a priority between them. And I think the personal representative would just open where they think makes the most sense.
That's what I was going to ask you. If you kind of the default would be to the personal representative after
Well,
we've exhausted like 1, 2, and 3.
Yeah, so the personal representative is the one that is filing the papers, like, the petition for probate to open the estate. So they would, I think they would be able to say that like they think it should be in whatever location. But they would really be kind of up to them to make. They're the ones doing the initial petition.
Okay.
So it would sort of be their choice. And I think in certain circumstances there could be options between different counties.
Okay. Thank you.
Thank you. Are there any other questions? No, thank you. Is there a motion on the amendment?
Move
I don't think I'm
favorable.
allowed to make a
You're
motion.
not allowed to.
Move favorable.
Thank you, Delegate Valentine. Is there a second?
Second.
Thank you.
Second.
Oh, thank you. And all in favor? Please indicate by raising your hand or saying aye. Any opposed? We'll do we'll do a roll
Mine
call.
was for aye. So.
Oh, good. Delegate Valentine? We're just doing a roll call.
Oh, I'm sorry. Yes.
Thank you.
Yes.
Delegate Sinet? You're a yes.
Yes.
Delegate Simmons?
Yes.
Delegate Simpson?
Yes.
Delegate Congolo, excuse me.
Yes.
And I am a yes. Now, is there a motion on the bill as amended?
So moved.
Thank you. Is there a second?
Second.
Thank you. And we'll do another roll call. I'm sorry, and I realized we didn't need to do it on the amendment, so I will not make that mistake again. Forgive me. Delegate Valentine, are you?
Yeah. Yes.
Thank you. Delegate Stinnett?
Here.
Delegate Simmons?
Yes.
Delegate Simpson?
Yes.
And Delegate Congolo?
Yes.
Terrific. Well, we have had our first successful vote. Mr. McFarland and Ms. Borlas, thank you for being here. You're welcome to go. We are going to now turn to House Bill 65, and if we could let in our witness on that. Delegate Cardin, do you want to discuss House Bill 65 very briefly? And
Yeah, I'd be happy to, just briefly, and then
Yep.
I know that we have Miss Pretieri.
Yes.
I couldn't pronounce her name in the hearing, and I won't be able to pronounce her name here.
She is here,
But she is incredibly articulate on this. This legislation provides clarity that communication between an attorney and a fiduciary is subject to attorney-client privilege, even if the fiduciary funds are used to compensate the attorney for legal services. This clarifying piece of legislation provides assurance that fiduciaries, for example, banks or other law firms or other fiduciaries, can obtain legal advice without compromising client confidentiality. Without clear statutory protection, fiduciaries may hesitate to consult with an attorney and may face uncertainty over whether beneficiaries could later demand access to privileged legal advice simply because such advice was paid for using trust or estate assets. Removing the ambiguity around this attorney-client privilege relationship ensures fiduciaries can confidently consult legal counsel and that beneficiaries receive accurate fiduciary administration. Right now, from what I understand, and you probably have done some research on this, Madam Chair, is that the case law is open. It hasn't been tested. There's many jurisdictions where there is attorney-client privilege. There's a few jurisdictions where there aren't. I think that the Maryland State Bar Association believes that the attorney-client privilege would be the appropriate way, that there is affirmative privilege is the appropriate way to go so that you don't wind up like that minority of states where you don't have that. I'll leave it there. If you have any specific questions, Kelly's the right person to ask.
Thank you so much. And is it I'm sorry, Kelly, how do I pronounce your last name? Forgive me.
It's a mouthful of vowels. It's Prederati.
Prederati. Okay, I got it. I will, if it's all right, I'll start off with a question, and then of course I'll open the floor. So I do understand as an attorney how valuable attorney-client privilege is and all the benefits, but I'm also aware that this is an area that many states have decided to allow the courts to make case-by-case decisions with factors and considerations like whether the estate paid for it because of this question of when it's a beneficiary, when it's a trust situation, whether the fiduciary truly is the client or the trust is the client. So I just, if you don't mind talking a little bit more about the state of law in Maryland and why this is not appropriate to be left to the courts, I would appreciate that.
Happy to do that. So the instance in which we've even seen the fiduciary exception mentioned in Maryland case law is the Trassetti case, and it's 2018 Maryland App Lexus 546. And in that case, the court merely mentioned that Maryland has some limited exceptions to the attorney-client privilege. However, the fiduciary exception is not one of them. And so what we are finding, I do nothing but trust and estate litigation, and this uncertainty is creating opportunities for lawyers representing beneficiaries to raise this issue, but it hasn't actually gotten litigated to a point where it's been decided by an intermediate or appellate court or the Supreme Court. And so they'll point to various jurisdictions. The minority of jurisdictions are the ones that have acknowledged there to be an exception, whereas a majority of them, either through statutes like Florida, where I also practice, or through case law, have acknowledged that there is no exception to the attorney-client privilege. And so the Maryland State Bar Trust and Estate section took a step back and looked at this and thought about where do we want to be in Maryland and what are we trying to promote in Maryland? And we want to be a trust-friendly state. We want trust to be established here. And I think we're fearful that if there is a recognized exception to the attorney-client privilege, given some other drawbacks we have, like income tax, Maryland will be less of a favorable jurisdiction for fiduciaries to come and administer trusts. I do a lot of work with corporate fiduciaries, banks, serving in a fiduciary capacity, but I also represent individuals. And I will tell you candidly, and I represent beneficiaries as well. So I'm not one-sided in terms of seeing the various ways fiduciaries are represented and need to be represented. But in the context of trust administration, like litigation aside, there are issues that fiduciaries need to discuss with lawyers that need to be candid, that need to be forthright, that sometimes involve some discussion that you wouldn't want the beneficiaries to see, whether it's dealing with how to make a discretionary distribution where there's an ascertainable standard that's tied to life choices, or making inconsistent or different distributions because you have an ascertainable standard that allows you to do that, and you're talking through the circumstances of one beneficiary as compared to another. It really isn't something that you would want all beneficiaries to see. And I think we're nervous that the ramifications of allowing a privilege like this to be overcome in a fiduciary setting simply because you're dealing with a fiduciary estate, we think the harm outweighs the benefit that could be articulated by a beneficiary. And just to come back full circle to your question, we haven't had the courts decide it. We have this one case from 2018 where it's sort of mentioned. And so, we've sort of waited for the courts to do something, and it seems like the courts might be waiting for the legislature to do something. And in the meantime, there's litigation that occurs at a costly level to beneficiaries where the lawyers are fighting about this. And I think there's a real opportunity for us to get out ahead of it, make clear our position where we would align with the majority of the other jurisdictions.
And if I could ask one final question, is this something, I think the answer is no, but could this be decided in the creation of the trust, whether or not the exemption would apply? I think no, right?
I don't think so.
Okay.
No, I mean, I don't think you could explicitly state yes or no in the trust instrument and have that govern.
Could you in the trust instrument decide whether or not funds could be used to pay for outside counsel and under what circumstances? Or not outside,
So
excuse me, outside.
oftentimes, trust agreements make clear that the trustee has the ability to hire counsel and pay counsel. There is also statutory authority to do that in Title 15 of the Estates and Trusts article. I have been doing this for 20 years. I have never seen a trust instrument say that the trustee cannot use trust assets to pay for counsel. And if we take a step back and think about circumstances in which someone serves and they're not a child or cousin or relative, the idea that they would have to come out of pocket to get advice to carry out their role as a fiduciary, it just doesn't make a lot of sense. And no one would serve in that role if they knew that, not only are they doing it as a favor to a family member or someone else or doing it as a business, but they have to come out of pocket in order to carry out their job. It would be a huge deterrent.
I thank you very much. Are there other questions? Oh, Delegate Valentine, yes.
Thank you, Madam Chair. And thank you to, and I do not know how to pronounce your last name, ma'am.
Preterati, Kelly.
Preterati.
But you can just call me Kelly.
Kelly. My question is this. First, I start with a statement, then I'll finish with a question.
Okay.
Thank you for the examples of why privilege is needed and some of the examples you gave between the fiduciary and the attorney. That makes sense, some of those scenarios that you provided. In your experience, can you give me some compelling reasons why, as a beneficiary, and some of the examples that attorneys have asked for what that communication is, why they would want that? Say, for example, as a beneficiary, I have private counsel, and I want to know what that communication is, like some examples of why it's so compelling. I need to know why the fiduciary and the fiduciary's attorney. Do you have any of those examples of why they would want that?
Sure. I can give you an example that I have in a case right now where we have trust-owned businesses that are going to be distributed. And we got some advice from counsel on whether the trust-owned businesses should be dissolved. And if so, the time frame, and the beneficiaries are trusts that will receive these assets, and they would like to know what the advice is that the trustee received on whether or not the businesses should be could be dissolved before they're distributed. And so in that case, I've been working with opposing counsel because I see why he wants it, and I'm working with him to negotiate a consent order that we would then submit to the court, making clear that there was no waiver of privilege, and to the extent that a waiver of privilege was determined to exist, it's contained to the memo that was authored by the attorney for the trustees in that instance. So there is a mechanism to go to court and explain to the court that you want to share, but you don't want to broadly open the door to waiving the attorney-client privilege. But without that, and without following a procedure of that sort, the idea is that it's broadly waived unless you're in the context of litigation. And so that the opening of that door would have the effect that I just described, and it might cause a trustee not to go seek that advice or to get the advice over the phone because they want to have conversations about candid things that otherwise the beneficiaries wouldn't be privy to.
Would this legislation prevent individuals in the future from having that ability to be on that specific request for that attorney-client? Like the scenario you just put in place, if this was passed, would I still, as a beneficiary 10 years from now, have that ability on a very specific case-by-case basis, try to obtain that information?
Sure. I mean, it would be the same place that we are now because I mean, I think the status quo is there is an attorney-client privilege. There is no statutorily or case law recognized exception. And so the privilege exists.
Mhm.
And so if we codify that to make clear that there is no exception, to dispose of this sort of ancillary litigation that occurs among lawyers for beneficiaries and lawyers for trustees, the lawyer for the beneficiary could still say, hey, did you guys get some advice on that? Because it would be really helpful for us to have. And the lawyer for the trustee could say, yes, we did. And let's enter into a consent order so that we can share that without broadly waiving the privilege. The privilege can still be waived. And it can be waived compartmentally as to one small thing, or you
Specific
just
topic.
have a, yes, yep.
Okay. Thank you. Thank you, Madam Chair.
Thank you. Those were excellent questions. And if I could ask a follow-up, if in that situation, it sounds like there's mutual agreement. What if there was not mutual agreement, and we either the status quo, we pass this law, does the judge have the ability to, if there's allegations of specific fraud, does the judge have the ability to force a disclosure in litigation?
I think it would be the same ability that a court would have to force a waiver of the attorney-client privilege in any context. And I'm more familiar with the ability to access work product related information because that is not an absolute bar to discovery. So I don't know the answer to your question because I haven't done that research, but it wouldn't be any different than the court's current ability to open up the privilege to someone who doesn't fall within the circle of trust.
I appreciate that. Thank you. Any other questions? No, well, this has been extremely helpful for me. We are going to table this, meditate a little bit, but I anticipate that we will have it on the voting schedule at our next subcommittee meeting.
Kelly, I'll make sure that if there's any more need for you to answer questions, we'll get in touch with you.
I'd be happy to do so. I think that this is a really important piece of legislation and will benefit the practice of law, the trustees who are serving, and ultimately the beneficiaries by avoiding litigation associated with this issue.
Thank you all so much. With that, unless there's anything for the good of the order, we will conclude our subcommittee.
All right. Thanks for your time.
Thank you all.